Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Today we're talking about the new ATF regs on NFA Title II firearms, machine guns, destructive devices, suppressors, and others. When firearms enthusiasts refer to the new ATF regs on National Firearms Act Title II firearms, they mean the federal regs found in the Federal Code of Regulations that took effect back in July of 2016. These regs covered for the first time trusts and other legal entities that wish to make or receive NFA Title II firearms. Prior to the new regs, the old regs only covered individuals, manufacturers, or transferees of NFA Title II firearms. So attorneys like me who draft NFA gun trusts for their clients are glad to have these new regs drafted and approved because they add clarity and rules for us to follow. Now, by way of background, no NFA Title II firearm may be transferred unless an application has been filed with and approved by the ATF and the transfer tax, of course, is paid. Both the transferor and the transferee provide certain information with the application. Now, here are some of the major provisions of these new regs that apply to transferring NFA Title II firearms. And by the way, Title II firearms include machine guns, suppressors, and other destructive devices. They're not your typical hunting rifles or handguns used for self-protection. Now, first, the regs define the term responsible person as an individual in the trust or other legal entity, excluding estates, who has the power and authority to direct the management and policies of the entity as it pertains to firearms. Typically, this means the settlors, those who set up the trust, and trustees, those who govern the trust, and it also can mean beneficiaries, those who benefit from the trust, depending upon how it is drafted. Responsible persons will also have to submit ATF Form 5320.23, the NFA Responsible Person Questionnaire. They'll also have to submit fingerprint cards and other identifying information to the ATF and undergo a background check with each new application. The ATF needs this information to ensure that each responsible person is permitted to possess a firearm. And a new application has to be made each time a new NFA firearm is transferred or to be transferred into the trust. Now, the new regs do away with the need for the chief law enforcement officer to certify each new application. The regs replace the chief law enforcement officer certification with notification. So now chief law enforcement officers need only be notified that a new application to receive an NFA firearm is being made. The notification must include a copy of the application and supporting materials. The notification must be made before the transferee is permitted to receive the firearm. And this closes what some refer to as a loophole, because under the prior regs, there was no certification or notification required at all when transferring an NFA firearm into a trust or other legal entity. Now, the new regs also clarify that for executors, administrators, people who handle, usually attorneys, who handle estates, when the firearm that's in the estate is transferred through the estate, it is not treated as an NFA firearm transfer. And also, it is exempt from the transfer tax, so that's good news. Now, what are some of the benefits of a well-drafted gun trust? First, expanded usability of the NFA firearms. The creator of the trust may name any number of joint trustees. Any trustee may make unlimited use of the trust assets. Any trustee may allow shooting acquaintances to shoot trust assets in their presence, and this typically occurs with the machine gun, and associates of the trustee will go to the gun range or the armory and they'll shoot the machine gun. That is all made possible under the NFA gun trust regs. Now, there are also estate planning benefits. Trust assets avoid probate and the time and expense associated with probate. Trust assets pass tax-free to named beneficiaries, thereby avoiding the Pennsylvania inheritance tax. Trust assets may be held for underage beneficiaries, and if the trust is drafted properly, successor trustees are given detailed instructions on how to handle NFA firearms, and that's very important because there are criminal penalties associated with not following the statute or the regs when being involved in NFA firearms. There are also asset protection benefits. Trust assets do not become contraband and possibly subject to seizure by the government when a trustee becomes disqualified from being able to lawfully possess a firearm. And trustees who become disqualified are automatically removed from the trust. That's the way I draft the gun trust. That protects the assets of the trust. And the trust retains ownership of trust assets for the benefit of the beneficiaries. Well, that's about all the time we have today for the Scaringi Law Lunch Break. I know it's a lot, but I hope you learned a little bit about NFA gun trust law. If you have any questions, if you'd like to set one up, or if you have any questions on the administration of one, don't hesitate to give us a call at 717-657-7770. Thanks for listening, and enjoy your lunch.